Good evening and welcome to this evening's talk. I'm Alan Benstock and I'm going to be your host this evening, as Jonathan Straight, your usual Minim host, is away from Leeds. This is a very warm welcome on behalf of both the Jewish Historical Society of England, Leeds branch, and Milim. Wherever you are in the world, you are welcome. And I'm delighted this evening to welcome viewers not just in Leeds, but around the United Kingdom, Israel, Canada, America, and hopefully, as I see a registration, Mexico. Our series of online talks and conversations continue with our guest, the historian Emma Cavell, I will introduce Emma in just a moment. Please ask questions. To do this, type whatever you would like to ask in the Q&A facility, which is a button either at the bottom of your screen or the top of a mobile pad. And as ever, we will try to get through as many of your questions as we can. I'd also draw your attention to the chat facility, which can be used to send a message or comment to all the other participants and attendees on this webinar, should you wish to do so. Finally, this event is being recorded and it will appear on the Minim website at minim.org.uk in the next few days. There you can find recordings of other past events, as well as details of our future programme and how you can book tickets. And so to this evening's speaker. Originally from Australia, Dr. Emma Cavell is a senior lecturer in medieval history at the University of Swansea. One of her areas of interest is the experience of Jewish women litigants in medieval England before the expulsion in 1290. She's previously held posts at several universities, including the University of Leeds. Emma is a fellow of the Royal Historical Society and is co-director of the Swansea Centre for Medieval and Early Modern Research. She's also engaged as a historical consultant for a major project to redevelop Caerphilly Castle as a major heritage attraction. This evening, Emma is speaking about litigation records and Jewish daily life in medieval English towns with reference to a specific case in Warwick in 1240. Emma, without further ado, over to you.
Thank you. Can you hear me okay? Everything all right? Yes. Thank you for joining me. I apologize for the mess in the background. I'm in our cellar and you can see all sorts going on. We're working on it, so it's a bit of a mess behind me. So litigation records are critically important and much neglected when it comes to the study of the Jews of medieval England. And it's at the focus of a lot of what I'm doing at the moment, looking at Jewish litigants in England before the expulsion, particularly women, and the negotiation of the boundaries of justice. In this paper, rather than look at the litigation record to illuminate Jewish legal action, I want to explore the ways in which the incidental detail of this particular plea that I'm going to look at helps to shed light on this sort of everyday, the mundane and so forth in Jewish life in medieval England. So what I have is a single case from the town of Warwick in the 1240s that I'm going to focus on. Now, in this case, in the 1240s, this case was recorded on the plea rolls of the Exchequer of the Jews, and it's graphic in its description and harrowing to read. In this case, Bessa, wife of Elias of Warwick, was assaulted and robbed one Monday afternoon in mid-September 1244 on the High Street of Warwick. So viciously is Bessa said to have been beaten that she suffered a bloody miscarriage. The attack was allegedly carried out by several members of another Jewish family from the same town, a man called Leo, son of Dulaban, and 6 of his relatives. What we know of the case appears on the record as 2 separate entries. One is, well, they're 2 separate criminal actions. One is a private lawsuit initiated by Elias, Bessa's husband, and the other is initiated by the justices of the Jews, and I'll explain what they are later, on behalf of the Crown, a sort of public prosecution, if you like. The latter resulted in the permanent expulsion of Leo and his family and household from Warwick. The story of the abuse of Bessa of Warwick belongs to a small number of cases in the surviving legal evidence that describe violent encounters involving Jewish women of the urban communities of England before the expulsion of the Jews by Edward I in 1290. These cases depict Jewish women as principal actors in episodes of physical violence, as victims, perpetrators, and parties to the litigation that sometimes followed. While the gender of the assault victim in this particular case, in the Warwick episode, is clear, it's also evident from the same record that 5 of the 7 individuals accused by Elias of being involved in the assault on his wife were women: Leo's wife Hannah, his sister Muriel, and his 2 daughters. Now, the case of Bessa of Warwick also serves as a Jewish addition to the 41 or so examples identified by the North American scholar Sarah Butler in 2005 of assaults on pregnant women in England during the 13th and 14th centuries. And it's the only Jewish case that I have yet found, but as I'm devising an application for a large collaborative grant to undertake a big study of Jewish litigants between 1190 and 1290, it's always possible that we may find more, but for now we've just got this one case. Now, I'm currently working on an article that will look at this case in close detail, the processes by which it was prosecuted, the way in which it was recorded on the rolls, what it tells us about community, gender, and so on. But what I want to do here instead is to demonstrate the ways in which the legal record is in fact a source of critically important information about Jewish life in 13th century England, and particularly in this case of Jewish life in Warwick in the 1240s. One thing about plea roll entries is that record violence or some kind of disorderly, disruptive behaviour is that we often get a lot of unique and plea-specific detail. And that's different from the rather more samey records of debt litigation, for example. And these details are important because the little bit of additional light that they shed on medieval England and Jewish life help us to reconsider some of the leading historiography of the Jews of medieval England, which, although things are changing and things of, say, the last 10 years or so have been slightly different, but this historiography has tended always to emphasize separation, indifference, mutual hostility, and so on between the Jews and Christians of medieval England. They're almost separate spheres in some of the historiography. Now, you will, of course, also get considerable detail in this case, and it's fairly harrowing, I should warn you. But before I get to the case, I want to explain a little bit about the institution known as the Exchequer of the Jews and about its records. So this is the institution whose records reveal this case. So you have some context. Now, the Exchequer of the Jews was a governmental agency with general oversight of the Jewish community of England, responsibility for collecting Jewish debts that had fallen to the king, and a central function as a judicial tribunal, principally for litigation between Jews and Christians. It was overseen in all its functions by the chiefly Christian justices assigned to the custody of Jews, or simply justices of the Jews. That's how we tend to refer to them now. And these justices sat at Westminster on a termly basis and were advised by the chief rabbi of England. Now, the Exchequer of the Jews essentially comes into its mature form. There's a lot of debate about its origins, but we see it in its sort of mature form by about 1219. So it's essentially a 13th century phenomenon. Now, the Jews of England had no right to common law, which is the king's law in respect of his Christian subjects. They were governed instead by jury law, which is a modern term and in no way contemporary, which was the king's law in respect of his Jewish subjects. This was the product of fixed privileges granted by kings of England, the terms of which changed during the course of the 13th century and remained distinct from both common law and also from rabbinic law. These royal privileges constituted the legal framework for the Jews' economic activities and their very existence as communities. It was this law that obtained at the Exchequer of the Jews. Now, I do have just a couple of slides to show you what I'm going to be talking about. So I'm just going to put them up now to give you some context. Hang on. I don't suppose you can see that, can you? Have I shared?
Not yet.
Not yet. Hang on. Okay, let me just try this instead. Hang on. Can you see that?
Yes.
Great. All right. I'll just now. The jurisdiction of the Exchequer of the Jews as a tribunal specifically was broad. It oversaw all litigation relating to the Jewish practice of money lending. It was largely responsible for litigation over title to real property that concerned the Jews, including the king's interests in Jewish tenements. It dealt with detenue, where one or other party was Jewish. Now, detenue is the technical term for in the English courts for the wrongful detention of goods or chattels, personal possessions. This was also the venue for the chiefly civil cases of trespass involving Jews or Jewish debt. And trespass is a much broader term in the Middle Ages, much broader than what we think of as trespass. And it's a non-criminal wrong that covers everything from physical assault to defamation and even fraud when it related to Jewish money lending and so forth. The Exchequer of the Jews also exercised jurisdiction over private prosecutions of serious crime where either party was Jewish, as well as being responsible for inquiring into the deaths of Jews suspected of having been murdered. The Exchequer of the Jews was unique in medieval Europe, and the extant plea rolls furnish greater detail of the legal activities of English Jews than any other record from 13th century England. Now, just to let you know what the rolls look like, what we're dealing with, the sorts of what the record looks like in the flesh, literally, as it's on vellum. On the face of it, the plea rolls of the Exchequer of the Jews resemble those of any law court in the king's jurisdiction in 13th century England. This means that they were made up of long, narrow membranes sewn together at the top and frequently titled front and back with the law term and sometimes the session. They are written in Latin, the language of government and legal record in England at this time. And yet, there's a big but, only about a third of the content of the plea rolls of the Exchequer of the Jews is to do with litigation, which makes that different from plea rolls of the other king's courts. The rest is other business relating to Jewish affairs, lending, recording of deeds, and so forth. In addition, there have been catastrophic losses. And so the rolls survive only patchily from 1219 to 1266, and then with greater fullness to 1286, especially from the early 70s onward. So we have to make do with what we have left, and we know that we've lost an awful lot, which is always a shame. Now I'm just going to unshare that. However I do that. Stop share. There we go. Okay, to return to the record that I want to look at, and the details supplied by the two entries on the rolls. The first entry is the first plea entered for Michaelmas term 1244, which means that the hearing took place somewhere between the 1st of October and the 21st of December in 1244, and probably early within that time frame, since this is the first cab off the ranks in the membrane. This is the first entry under that title. In bringing his private suit to court, Elias of Warwick's case is this. On Monday next after the feast of St. Matthew the Apostle, 19th of September, a little after noon, 3 o'clock in the afternoon, on the high street, Leo, son of Juleben, and others encountered Bessa and set upon her so viciously that she subsequently lost her unborn baby. They also stole from her a gold buckle and 8 gold rings to the value of 10 marks. Elias tells the court that he's ready to prove what he says by the country or by his body or by whatever means the court chooses. And this means, what he means there is that he's willing either to put his claim before a jury, that's the reference to the country, and this time, in this day and age too, the jury do a fact-finding body. They are not just the decision makers in the room, locked in a room in the modern sense. They actually, the jurors in the medieval common law go out, or courts, the King's Law courts go out and do a fact-finding. And his other option is to take part in a judicial duel, which is to prove this by his body. And the judicial duel was the original form of proof in a felony case, which dates right back to the beginnings of the post-conquest crown legal system. And then, of course, he says, or any other method that the court sees fit. The defendants, Leo and his family, not only denied the charges, but also sought to have the appeal thrown out on technical grounds which we don't need to worry about too much here, say that they claimed both that Bessa should have brought the case herself, since she was alive, and that Elias didn't see or hear what he now alleges, so shouldn't be allowed to relate the story as if he did see and hear it. Elias responds that this is to do with the damage and the harm done to his child and the theft of his chattels. The defendants then asked the court to take into account the fact that they weren't found in possession of the items that Elias claimed was stolen from Bessa. More importantly, for our purposes today, the defendants offered their own very different version of events. In this one, it is Bessa who is the aggressor, with mysterious others whose names are not given. Bessa apparently attacked Leo's daughter Antera in the street, and curiously enough, it says she ate or chewed away or devoured, the Latin's comedit. She did this to Antera's nose and ears. Leo's wife certainly came to Antera's aid, and that's why she was there, but neither Leo nor anyone else in the group laid a finger on Bessa. And this they wish to have put before a jury. They also claimed that after attacking Antera, Bessa went home to bed, covered herself and the floor around her bed with animal blood, and lay down. And this is the first we read of the blood, but the implication is clear. There was no miscarriage. Bessa had faked a pregnancy loss. Now, the justices dismissed Elias's suit. No reason is given in the entry, but we learn in the subsequent entry relating to the inquest on behalf of the Crown, that I'll talk about in a minute, that he is in mercy, which means basically that he was handed what we would now call a fine for a false charge of robbery. In effect, it was a dismissal for a technicality, as many cases in the King's Law Courts were. In the common law courts, for example, you might have your case thrown out if you had got someone's name slightly wrong, or you listed only 5 of 6 daughters of a landholder because the 6th one had died, but you didn't mention her. The technicality of this case was likely to have been the disconnect between the value given by Elias of the gold ornaments Bessa was wearing and the juror's declaration that the value was not known. Yeah, we'll see. So it's very easy to be non-suited. The court wasn't necessarily saying that there was no robbery, that no robbery had taken place, just that the details don't match exactly. So once Elias's suit was dismissed and the justices ordered an inquest, and I've jumped, we'll get into the inquest in a minute, I've jumped forward a little bit to say that the jurors declared that the value of Bessa's ornaments were not known. But the justices then dismiss Elias's suit and order an inquest to be carried out by 12 Christian jurors on the king's behalf into the breach of the peace. It was within the power of the justices to do just that, and they very often did, because it was clear in this case that a very serious incident had taken place, which had disrupted the king's peace, and that it needed to be dealt with seriously, even if Elias himself had been non-suited. The results of the inquest were brought back to the court at the Exchequer of the Jews on the octave of the purification of the Blessed Mary in the 29th year of the reign of Henry III. So that's February the 9th, 1245. The narrative provided by the jurors more closely mirrors the version of events put forward by Elias than that of his opponents, though it is more detailed and more emotive than Elias's own appeal. Unlike the appeal, this account purports to incorporate eyewitness detail. We read that on Monday next before the Feast of the Apostle, a little before noon, so exactly the same day and time that Elias had said, Bessa, wife of Elias of Warwick, was set upon in the doorway of his synagogue a little after noon. She was first kicked to the ground by Leo and then dragged into the street by her hair and beaten by Leo's wife, sister, and daughters. Brought to her bed, she miscarried a child which was as yet too young for the sex to be determined. It was also said that Bessa had been wearing a buckle and rings of gold, but that the number and value had not been determined. So I jumped the gun there, but this is why Elias's suit was probably thrown out, because he gave very specific values and the jurors were unable to concur. So Elias's suit couldn't succeed. The inquest also found that Bessa had not attacked or beat Antera or gnawed her nose and ears. And so Leo and his family were committed to prison until such time as they'd made satisfaction with the king and the law, so basically until they'd served a punishment, and their chattels were taken into the king's hands. Elias was immersed, so he was fined for a false charge of robbery. And then finally, the parties reached a settlement. Leo and his family would abjure the town of Warwick, to leave within 8 days and never return, and Leo would find pledges that no harm would come to Elias through him or anyone connected to him. It's a bit of like a restraining order, I guess. What the Warwick case reveals with striking clarity is the centrality of family and community, both to the unhappy episode described in the record and to the legal processes that produced the record. In September 1244, there stood on one side a husband and wife, and on the other, a pater familias with his wife, sister, 2 daughters, a son, and a son-in-law, each of whom was variously implicated in the violence, to some extent, in one way or another, by the 2 plea roll entries. These men and women belonged to a small Midland Jewish community that had either survived the royal order for its expulsion from Warwick in 1234, which was during a period of government-directed Jewish relocation in the 1230s, or it had quickly re-established itself. Independent evidence shows that there was a community there again, or still there, by 1241, just 3 years before our episode, and that it was one of the lowest tax-paying Jewish communities in England in that year. However modest the Warwick jury, the disputants appear to have belonged to its upper echelons. Elias and Bessa were wealthy. We know from the litigation records that Bessa was wearing ornaments of gold of considerable value, even though the jurors had been unable to determine the exact value. And Elias, well, he seems to have been the community rabbi, for the inquest into the breach of the peace reported that Elias's wife had been attacked at the door of his synagogue, Adianitam Skole Sue, is what the Latin says, a building which Elias's private appeal shows was on the high street. Perhaps since Bessa was encountered at the door, the building was also the family home. We don't learn as much about Leo and his family from the plea roll entries that we have, but Leo and Elias are both listed as Jews of Warwick on the tallied roll of 1241. And these 2 men may also have been the Elias of Warwick and Leo of Warwick summoned with at least one other Jewish man from Warwick to take part in the investigation surrounding the violent death of Solomon Turb in Gloucester back in 1220. He fell from the tower of Gloucester Castle, where he was imprisoned. Now, so Leo and Elias and their families, they were presumably too well known and too well connected within the community of Jews in Warwick for other Jewish men to have taken part in the inquest as jurors in the inquest of February 1245, where we would normally expect to have seen Jewish jurors alongside the Christian ones. In addition, the plea roll makes clear that the violent altercation took place on the High Street, in public, in the middle of the afternoon. The High Street was also known as the High Pavement, and it ran in medieval Warwick, and it ran parallel with Jury Street, which is now spelt as in judge and jury, but was recorded in the mid-14th century as le jury, i.e. the jury or place of Jews. High Street and Jury Street ran from Eastgate to Westgate and intersected 3 other main roads running north-south through the town. These were Castle Street, Church Street, and Northgate Street. A late 15th century record refers to 10 chief houses in High Pavement in Warwick. So perhaps a scholar and possible private home of Bessa and Elias was one of these. Moreover, there are enough witnesses to the brawl and its aftermath that the Christian jurors of 1245 were able to assemble fairly intimate details about what had taken place. Whether these bystanders were Jews or Christians is not stated, but it is not improbable that there were both among those who saw what happened in the street, if not also among those who gathered at Bessa's bedside afterwards. So we know from the inquest that a lot of the detail comes from observation at Bessa's bedside. It's clear not just that the Jews of 13th century Warwick lived cheek by jowl with the majority Christian population of the town and occupied some of its central locations, but that the women of the community probably moved about the streets as freely as the men. It doesn't seem likely that Bessa or her female adversaries lived in any sort of isolated domestic seclusion. They were central to the brawl on the streets, whichever side you believe. And indeed, the defendant's version makes women the only ones involved in the violence. It's also most unlikely that, as one modern commentator states, the Jewish community of 13th century Warwick made little impression on the town. While moving about the town, rubbing shoulders with their Christian neighbours, Elias, Bessa and their adversaries would have been confronted on a daily basis with the churches, churches, spires, crosses and other artefacts, if you can call them that, of Christianity. At that time, Warwick had a church smack bang at the intersection, on the intersection of those main roads that I just described, although it was moved in the later Middle Ages. We know that at other times in other towns, Jews came and went from churches and monasteries and so forth if business was to be conducted in those places and so on. The plea roll records also show us that the very frames of reference used by Elias, Bessa, Leo, and the others in taking their dispute to the king's justices was strikingly and inescapably Christian. In 2015, the Israeli scholar Elisheva Baumgarten demonstrated the extent to which the Jews' contact with Christian artifacts, religious artifacts, rites, sacred spaces, and so forth in their daily lives showed the extent to which they came in contact with these things. And she also showed that they were fully cognizant of records of Christian holy time, the calendar of holidays, and saints' days. And this reality, I would suggest, was nowhere more obvious than in the use of the king's law courts by the Jews of medieval England. The Christian ritual calendar framed the legal calendar of the English king's courts, sort of represented the pegs on which the legal calendar hung, and furnished the dating conventions used by the court, its records, and all of those who took part in the legal processes, from the presiding justices to the ordinary litigants were aware of this. That this was the case is true for the Exchequer of the Jews, just as it is for any of the king's courts. And that's clear. Elias's case rests on the events occurring on Monday next after the feast of Matthew the Apostle, a little after noon. The jurors responsible for the inquest came to court on the octave of the purification of the Blessed Mary in the 29th year, and so forth. And it probably matters little whether Elias made his case in those specific terms when seeking justice, when he did that himself, or whether the phrase was uttered by his pleader, if he had one, or interpolated into the written record by the court clerk using standard dating conventions. For Elias to have exploited the avenues of secular legal redress open to him in England in the 1240s, he had to be acquainted with the court's operational schedules, with the forms of action, the rules of pleading, and all those saints' days and liturgical hours of Christian timekeeping that necessarily framed his case. He would have been familiar with the dating practice at the very least. And as Baumgarten's research has shown, the Christian calendar would have informed the rhythms of Elias's daily life. Still more intriguing is what Elias is recorded as saying he's willing to do to prove his claims. The forms of proof he says he'll offer. One of them, you'll remember, is the judicial duel, so trial by battle, a traditional form of proof for a felony appeal in common law. It's a Norman thing, so it's very, very old. Although the judicial duel originated in pre- and non-Christian legal systems, in this context here, in the sort of post-Norman, in the Norman dispensation, the brave new world of post-conquest England, it's one of the most strikingly Christian adjudication processes employed by the English king's law in the central medieval period. And we also have the ordeal, which is very similar. Battle and ordeal depend on the idea that God directly intervenes on the side of the right, in this case on the side of the person telling the truth. And similarly, in an ordeal, God would signal the innocence or guilt of the person on trial. So proffering battle as a form of proof also depends on a belief in the judicial efficacy of such a process. So Elias, or someone on his behalf, was signaling that they subscribed to these notions, at least ostensibly. Potentially, of course, everyone was indulging in a sort of shared fiction by this point. because by the 1240s, by this time, felony appeals almost never went to trial. They almost always they almost never went to battle. They always went to a jury trial, pretty much. It's very rare to find an actual judicial duel. I mean, you will, but it's rare. So Elias may never have really thought that was on the cards. I think it's much more likely to have been a statement of sincerity and intent. This is absolutely what happened, and I'll do it, I'll prove it in any way you see fit, rather than a genuine offer to do battle. Nevertheless, in the use of the legal venues provided by the Crown, Elias, his wife, and fellow litigants at the Exchequer of the Jews were both willing to exploit these judicial processes, forms of pleading, legal fictions, forms of proof, and so forth, and to use the Christian dating conventions, symbolism, and so on of the court. In this sense, they're also complicit in the perpetuation of this system. But at the end of the day, what we have here is a case of abortion by assault perpetrated against a Jewish woman from Warwick by other Jews of Warwick. So evidence of deep enmity within the small Jewish community of Warwick in the 1240s. However long-standing, or how long-standing this enmity was, and what the underlying causes are, we just can't know. But it must have been serious for Elias to pursue an appeal. It's called an appeal. So it's actually a private prosecution, and it's not appeal in the sense that we would understand it. But appeal is the word used when you bring a private criminal prosecution against someone for a serious crime. So it stands in contrast to trespass, which I'll explain in a second. So it must have been serious for Elias to pursue an appeal when appeals were notoriously difficult to win, and when abortion by assault, as Sarah Butler has shown, was especially slippery, imprecise, and difficult to prosecute. Pursuing Leo and his family on a charge of trespass, chiefly civil litigation, would have been far more likely to succeed, would have brought monetary compensation, and was usually the route people took. However, a guilty verdict on an appeal usually resulted in death, the death penalty, and forfeiture for the appellees, that's the defendants, which is presumably why they were so hard to win, which is probably just as well. There are a couple of possibilities here, I would have thought. The first is that Elias's anguish over what had happened to his wife and child was so great, or his enmity toward Leo and his family already so deep-seated, that he actively sought the death penalty and was prepared to pin his hopes on the slim chance of success. Or, and this I think is probably more likely, Elias knew full well that he'd be non-suited, or was highly likely to be non-suited and fined. And if he was a fairly wealthy man, as it appears he was, the fine would have been manageable. But he was aware that the court would take up the case on behalf of the Crown, on behalf of the King, and a fairly heavy-handed punishment would still be handed out. Rather than being awarded compensation, Elias succeeded in having Leo and his entire family and household removed from Warwick. And I suspect this is probably the more likely reason. And if this is the case, it suggests a man very well versed in the subtleties of the system. And one last thing worth reiterating is the centrality of the women to the affair. And perhaps indeed the quarrel originated with the women. Who knows? Thank you.
Sorry about that. Thank you, Emma. I'm just it's a bit difficult when normally I'm behind the scenes. Thank you. That was most interesting. As I said earlier on, if you have any questions, please put them in the Q&A. We do have some. I've also got some of my own here as well. So if you're ready to start with, early on when you were showing the slides of the roles, this prompted Sonny Koski to ask, how were the roles lost?
Good question. Almost certainly. I mean, we have lots of cases of records of the Crown law courts lost in floods and fires, but I think we have so many losses amongst the plea rolls of the Jewish Exchequer, and I think that there is probably deliberate destruction and so forth. There's right throughout the history, there are bouts of violence and record destruction by people who realize they contain a little bit too much information about what money they owe the Jews, and we might just carry off this chest of documents and burn it or something like that. So I suspect there's more to that than that, you know, but it is really unfortunate because we have such huge gaps.
All right. And just as way of background, when we refer to the roles, that is where is it not where the term the master of the roles comes from? Are they the same roles?
Not the same roles, but yeah, I mean, the master of the rolls is a post for looking after certain administrative documentation of the crown. I mean, the English crown is notoriously bureaucratic. So we've got records and duplicates and triplicates and yeah, enrollment, that's where enrollment comes from. Yeah.
Now, Irene Glauses, apologize for mispronouncing a surname there. Is it known how many Jews were living, she says there, I presume Warwick at the time?
No, it's difficult to estimate the Jewish population in the whole of England at any given time. The estimates vary, several hundred. It's very small, but then you think that the population of England at the time was far, far less than what we're dealing with today. It may just have been a handful of families in Warwick, you know, and they've got a synagogue, they've got a rabbi, you know. It can't have been very many people at all, but it's very difficult to estimate. Yeah.
Yeah, and Irene goes on to ask, was the community tolerated?
Yeah, I mean, that's just the thing that this Israeli scholar Elisheva Baumgarten and I, with these litigation, we're looking at everyday interaction. So we learn a lot about the outbreaks of violence and the pogroms and things like that, the things that occur. But on a day-to-day basis, I think they're rubbing shoulders, they're mixing, they're in and out of each other's. We have records that show they're in and out of each other's houses. You know, and they're certainly not separate spheres. And I think the English historiography has tended to emphasize that the Jews lived in their own kind of world and they didn't talk to, you know, they were separate and they didn't like Christians didn't like them. You know, I think they were, yes, I think on a day-to-day basis, they were, if tolerated is the right word, they were neighbors.
Thank you. Now, there's a couple more questions, and I'm just going to have to put these together. But before I do, there's a couple of people that have got their hands up, indicating they might want to ask a question. But as we're running a webinar, if you can put them into the Q&A or the chat, I'll pick them up that way. Right. John Cowell, I'll read what he says. I think, Emma, you said that Elias's valuation of the jewels was disputed by the other side. If that is right, was it for some special reason, such as a member of Leo's family knowing more about the values of the Jews? And does it appear that Elias the rabbi also traded in Jews? And he then goes on to ask, was it perhaps that Elias was trying to get rid of a competitor?
No, yeah, it was. So Elias says they're worth 10 marks. It's the Jew. So, and all that the defendants say is, please could the court take account of the fact that they weren't found in possession of any of these items. That's all they say. It's the inquest, the jurors that are assembled, Christian jurors from the county of Warwick and the county of Warwickshire and the town of Warwick are assembled to go and find out, and it's they who report that the value isn't known, that Besser was definitely wearing some items of that description, but the value just isn't known. So when it comes to the rivalry, you know, between Leo and Elias, anything is possible. It could be the women's quarrel, it could be Elias and Leo, it could be the families have hated each other for generations. We just don't know. And yeah, I mean, Elias may have had other jobs, you know, he's the rabbi, but he may also have been a lender. Leo might have been a lender. We really don't know very much about these two people, except in Elias's case, what we can glean from the detail in the plea roll, and then in Leo's case, and a bit more just looking for him on the tallage rolls. How much does he pay? Is he, you know, where we find them. And interestingly, we never see, well, I mean, I'm still looking, but I've not yet found Leo and his family after they've left Warwick. I don't know where they end up.
Now, I think you did say how big the Jewish community was at the time, but Geoffrey Hillman does ask how big the Jewish community was. Now, he then brings in another question, which actually captures the same sentiment from a couple of other people. How big was the Jewish community, and did they not have a Beth Din court for internal community disputes, which is a rabbinic court?
Yeah, for a long time, that was in France. That's the interesting thing. So the Jews' internal disputes, marital disputes, and other issues weren't the business of the Exchequer of the Jews. The king didn't want to, it wasn't interested. That was internal affairs. They did use rabbinical courts. The Beth Din was in France, and they would have to go if they and we do have a marital breakdown where one party goes off to France and so forth, but Henry III says, no, you have no right to do that. I'm going to tell you. But Pinchas Roth in Israel a scholar in Israel has actually written an article on teasing out all the references you can find to rabbinic tribunals in England, and little references in records and so forth that shows that there were smaller tribunals taking place in England for internal affairs and so forth. The Exchequer of the Jews deals with anything that the king has an interest in, from money to crime and disruption. Any kind of peace breaking and violent aggressive behavior has to be investigated. So yeah, the Beth Din was in France for a long time.
Thank you. Now, there were a couple of questions, but which again, similar theme, but best summarised by Gordon's question. Were the litigants represented by lawyers, or were they speaking of themselves?
Good question. It's always difficult to be sure, but we know because the records are written in a formulaic manner, and it's not always clear. But we know that in common law courts and so forth, so if you were going before the King's Bench or the Court of Common Pleas or something, you would have an attorney, usually a professional attorney, who would take your case to the court. You would have a pleader who would so the pleader is a barrister. The attorney is the solicitor, became the modern solicitor, and the pleader became the barrister. And the pleader had to know how to render your case into account, which is the narration of the case in court, in law French in particular. So he had to be very skilled, and he was the pleader. And in most cases, one would expect, I would expect it's likely to be exactly the same in the Exchequer of the Jews. We know they have attorneys. We know they use attorneys. That's always turns up in the record. I would assume that Elias would have a pleader because the count is so sophisticated. So, it's done, the count, then the rejoinder. There's a whole of technical terms as the two sides have the sort of a dance, a to and fro dance, and it's all done in French and then rendered in Latin in the record. I would say Elias has a pleader, but I couldn't prove it.
Yeah, but there was nothing, taking part of a question that somebody had dealing with that there was nothing preventing a Jewish person defending themselves that you could see. No, and actually the Exchequer of the Jews is slightly different from the common law courts. Obviously, I've mentioned that jury law is what is used there. The forms of action are very similar to those in the common law courts, or not identical, but very similar. The law terms are very similar, but not identical. And the justices of the Jews, who are Christians, are actually also big names in the court of the King's Bench and the common pleas and so forth. They have different hat on. And the Chief Rabbi of England advises in the Exchequer of the Jews, but there's no reason to why there should be any disadvantage or no right to represent or whatever. Going back to the specifics of the case, what were do you know the ages of the people involved? Bennett asks.
No, well, obviously Bessa was within childbearing age. It's pretty certain that there was a miscarriage. It's you know, that because the witnesses at her bedside saw a fetus, and it's actually really a horrible case. And so she's within childbearing years, so presumably Elias, well, not presumably anything, he could have been a much older man, who knows, but she was. And yeah, that's the only one I could say that we know for sure. I suppose Leo's daughters could have been anywhere between sort of, you know, adolescents through to middle-aged women. It's really hard to say, but Bessa's within childbearing years. So
thank you. And just again about time, do we know where this Jewish family or Jews came from, and where were they born?
Well, I mean, by this stage, the Jews have been in England since first recorded Jews in England is 1070, so 4 years after the Norman conquest. We think William the Conqueror brought them over from Rouen. So originally they've come from France, and originally they live only in London, and a few reigns in, they start moving out into the provinces. Some communities stay put in the towns, you know, they're born and raised there, you know, they're many generations English, if you like. But there's also a lot of migration between the towns. You get them moving sometimes, and you get displacement. Like we don't know whether the Jewish community did leave Warwick, but there was an order for them to leave, and they're back again within a few years. So it's hard to say where they're born, but they could be born in Warwick. Equally, they could have been born in Gloucester or something like that, but they will be born in England. These are many generations in England.
Now, thank you. Now, the final question we've gotten is from Valerie Bodansky. How did you find this particular case? A case of domestic violence, so which in itself is a family case overlaid with an overlay of crime.
By reading the plea rolls, by going through, I was looking for women. So my background is working on women. And I started working on aristocratic women in the Welsh Marches, looking at frontier and all of that. Then I got heavily involved in litigation and all of that kind of thing, women litigants. And then I realized that Jewish litigants had never been looked at for England. The plea rolls were there, but they'd been exploited for other things. And I was looking for women, which meant just basically reading everything. And I just read through. You can do that because there's so many losses. You can actually read everything, you know, slowly. It's painstaking work. And you come across some really, I mean, this isn't the only one of Jews attacking each other and so forth. I mean, you expect all the violence to be between Christians and Jews, but actually there are other cases that I've come across where Jewish people beat the hell out of each other and the streets, and the king then, you know, the courts prosecute this disturbance. Yeah.
So where are these rolls kept now? Are they in the National Archives?
Yes. Yeah.
So that's a Kew.
Yes, in Kew, but some of them are published. Most of them are in published form in one form or another. The earliest ones from the Edwardian period, and they're as in the 20th century, you know, around 1900, not as in Edward I. They are not very good. They're just calendared. But yeah, you can start by looking at published versions. A lot of them have been photographed and placed online, just rough and ready photos of the membranes, by a big project that was done by an American scholar. He was interested in the justice system, the medieval justice system, and how it's a precursor to what goes on in the US today. So he photographed common pleas and King's Bench and Exchequer of the Jews and you name it. He had a whole team just photographing. So you can also look at photographs, but they're rather difficult to navigate. Ideally, you go to Kew and you look at them.
And Charles Kaplan has asked, perhaps, does that mean you read Latin?
Yes, yeah, I have to. Yeah,
and
I mean,
presumably
I read
proficiently.
Yeah, well, medieval workaday Latin, yes, and I read so many of these, and they're formulaic, and charters. I work with monastic charters and all sorts as well, and financial records. You get so used to what you're seeing that it's not actually very difficult. In fact, one of the more difficult things is not the Latin per se, it's the hand. You've got to get your eye on the hand in which it's written. And also, the court clerks in this case will never write the words out in full. If they're stock phrases, they'll just write this in like a letter and a squiggle and a this and a that. And you have to know what the series of like almost hieroglyphs, it's shorthand. It's like shorthand in the court, and they will write that, and you have to know what you're looking at. So that's the greater challenge than the Latin. If you were given the sort of Times New Roman fully written out Latin of what's in the plea rolls, very quickly you would also pick it up and know.
Peter McDonough asks, have you published an academic paper on this subject?
Yeah. Yes, not this case yet. I'm working on it. Yes, I've written in the published earlier this year in the Law and History Review, which is an American journal. I have an article on women litigants at the Exchequer of the Jews, looking at sort of quantitative and basically challenging the idea that, another quirk of English historiography of the medieval Jews of England is that there's this idea that Jewish women are much better off in a much more socially elevated, more respected position than their Christian counterparts, who were just had no rights and were, treated very badly. That Jewish women were treated better than that. And also that the Exchequer of the Jews is a sort of bastion of equality for women. And this article challenges that notion by comparing women's litigation, the Jewish women's litigation in the Exchequer of the Jews, with what's been done on Christian women. A lot has been done on Christian women litigants, and saying, well, actually, this is nonsense.
Dean Irwin has actually put in the chat a link to a paper, I think.
It might be. Is it called Measure of Her Actions?
Yes.
That's it. That's the article.
Right.
Thanks, Dean.
Right. What I propose, if it's all right, if you can send me the links, I will put them on our website. So if people would like to read them, we can do that.
That's fine. Yeah.
Going back to the chat, there's a couple of questions, kind comments from Yvonne in Southern California, who's been listening, never aware of this particular part of history before, and she's really grateful for the talk. One question from Leon Collins. Do you know what language the Jews use when talking to Christian townsfolk in the city?
Well, it's probably French. It's so the Jews themselves tend to be I think it's a Norman dialect of French. I mean, the French of England is a Norman French anyway. Even as in the towns and that English is starting to be spoken, the Jews, French speakers, they probably communicate in French with the townsfolk. We certainly know they do. They are communicating. They're conducting business together, and there are stories of on Shabbat a Christian lighting the candles for a Jewish neighbor because the Jewish neighbor can't do that. So I would say French, and also the pleading in the law courts is done in French as well.
Oh, that's interesting. So, despite the record being in Latin, it was the pleadings and the actual dialogue was in French.
Yes, absolutely. That's the case. Whoever you are, whether you're a French-speaking aristocrat, a French-speaking Jew, or an English-speaking, serf, or something like that, the pleading and so forth is done in French. And the records in Latin, and that's a quirk of Norman. That's the function of the Normans bringing that. So Latin is the language of government and administration for the Normans, and they introduced that in England. And French is the language that they're speaking, and that comes into England as well, which is a completely different. If you go back before the conquest, the formal Anglo-Saxon English is the government language as well as the spoken language, and it's everything. So it's quite different. It's a real break.
Well, that has been fascinating. As ever, the number of questions demonstrates the interest you've triggered us all. But I think we've come to the end of those that I've got listed. So if nobody's got any other questions, I'd like to take this opportunity for thanking Emma for being our guest this evening. And as is now our tradition, now hopefully this will work. Yes, we're going to be sending you a copy of Jonathan, the normal Minim Hosts book, a photograph collection by Jonathan Straight of Magen David Adom, the Israeli Emergency Services, a book he's done. I'll get that to you if that's okay.
Brilliant. Yes, yes, that would be brilliant.
Different from your normal history.
That's all right. I'd love to see it.
Yeah, the ambulance service in Israel. So, to our future program that's coming up now, because it is we're in the middle of the Jewish New Year. I've just got to get this the right way around. We've had for people know, we've had a few little technical problems, so that's why I'm doing this all myself this evening. Although I've just spotted a question, and I actually think this is worth asking. Selma Avoth, did the Jews wear distinctive clothing? Do you know, and what were their professions?
Well, distinctive clothing, probably they wore very similar clothing normally. However, we start to see, and I can't remember what the first year that we have record of in England requirement that they wear an identification badge. 1218, thanks, Dean. They're forced to wear at one point a strip of white linen pinned to their breast to say they're Jewish. So what went on in Nazi Germany was by no means original at all. In other parts of Europe, they're forced to wear, well, they wear pointy hats or whatever. There are laws saying the Jews must wear something to identify themselves by. So once that comes in and it's really enforced, you would spot a Jew a mile off. And yeah. And what was the other question? There was another part.
That was what were their professions? Professions.
Well, obviously the big one is money lending. Everyone knows money lending. That's why we think William the Conqueror brought them in to help finance his ventures. And we know that the marcher lords, so I work on the marchers and aristocracy, they borrow from the Jews and all that. So they're big money lenders, but naturally they would therefore have with them servants. They would have ritual butchers. They would have all the kinds of professions that one, bakers, all the kinds of things that one would need to survive. So they are not just going to be money lenders, but a lot of the very prominent Jewish individuals in medieval England are very, very wealthy financiers, men and women too. At one point, there's a man called Aaron of Lincoln, who's a 12th century Jew, and he is thought by some to have been wealthier than the king, or second only to the king. He was so wealthy. So money lending is the big sort of poster boy profession, but then there are obviously going to be all the other professions required in the community.
Well, I'm definitely going to say we've covered all the questions this evening, and again, thank you very much, Emma. So now to our future programme. Our next talk is next Sunday. No, it's not next Sunday. It's a week on Sunday. Should be. I'm just checking the dates here because of the festivals. Yes, it's a week on the Sunday, the 26th of September, when we will be having a very special talk by a special Sukkot program, a talk with filmmaker Eden Project trustee Jonathan Durori, CBE, who will be talking about his books Around the World in 80 Trees and Around the World in 80 Plants. The following Thursday, the 30th of September, we have a football special. Joe Aref will be discussing his work, and again, please excuse my pronunciation, Gerasona Wunder Team, the rise and fall of Austria's Wonder Team. And finally, for now, on the 11th of October, impresario Raymond Gabay will be talking about his 50-year career promoting Russian ballet, classical music, and more. And I do know he will be mentioning Leeds in the talk. We have an extensive program that's coming up, including infills in between the talks we've got. Full details can be found on our website, milim.org.uk, where you will also find recordings of previous talks and a link, which I've also placed just in the chat, where you can make a small donation to help support our work and the costs of providing these webinars. Also at the website, you can sign up for our regular bulletins. So it remains for me to thank our guest, Emma Cavell, once again for speaking today. Thank you. And I'm looking forward to seeing you all at a future event. Until then, as Jonathan regularly says, stay safe. See you soon.